Good afternoon. My name is Luke Terwilliger, and for my research project, I examined court-ordered counseling services. Here is a brief overview of what I will cover with you today. The first section of my presentation will discuss what court-ordered counseling is, and then we'll talk a little bit about whether or not it works or is even beneficial. We'll then move towards implications for counselors or for us, for counselors in training, and then we will finish up with best practices should a counselor engage in working with clients who are court ordered to counseling. Now, before we get into some of the research on court-ordered counseling, just want to take a minute and review some of the core tenets of counseling that we've already been exposed to. In reviewing our codes of ethics, we already know confidentiality is one of the primary responsibilities of counselors, where we keep and maintain records safely and securely and don't divulge client information. Also, we ensure that our clients' participation in our counseling sessions is done so with their informed consent, meaning we've provided knowledge to them on the process and the options, as well as the benefits and risks, and they agree to participate and acknowledge they understand the information that we shared regarding the process. In that note, voluntary participation is another core tenet where the client has the right to stop treatment, they can leave at any point, they have full autonomy in whether or not to continue in that therapeutic relationship with the counselor. And then finally, of course, the counselor's ethical obligation to first do no harm to their clients. And so please keep these core tenets of counseling in mind. Of course, they're not all of them, but these are very important ones. So be mindful of them as we explore some of the information regarding court-ordered counseling. So what is court-ordered counseling? Well, outside of the obvious self-explanatory definition, a court-ordered client is required to attend therapy or counseling as a condition of their release from jail or prison, or sometimes even in lieu of a jail sentence, or it may even be issued as a requirement for a first-time offender in the judicial system. Part of what I learned in exploring the research on court-ordered counseling is that it can only really require attendance, not necessarily engagement. Kind of the idea that you can lead a horse to water, but you can't make it drink. You can have that person go, but to what extent they can or they must improve or how it's measured in their level of engagement is sort of up for debate, which we'll get into a little bit more later. But keep in mind that it does require their attendance to go to some form of therapy or counseling, depending on that specific circumstance. In that note, providers typically would be expected to report whether or not these court-mandated clients attended either individual or group sessions, and they may be asked to report on additional details, provide their recommendations, or update the judicial system on their progress as well. And this is most commonly used for substance abuse or domestic violence, is what I learned through the research that I conducted. Part of it, I think, has to do with obviously, if a person is voluntarily going to counseling for their own life crises or perhaps marital issues that has not yet involved the legal system, there's no legal reason for someone to be mandated to go. So there's got to be some sort of crime in place or legal violation where they would have been before a judge for that judge to then require them to go to therapy. And so that often related to substance abuse or domestic violence. So, moving on to court-ordered counseling and the research. Is there a benefit? Well, some would say it doesn't work. In part of the research I found, I discovered a study regarding teenagers who had been convicted of substance abuse crimes or drunk driving, and some were required to attend a presentation from Mothers Against Drunk Driving, or MADD, that required a few hours of their time. There were videos and educational material shared on some of the horrific results of teenage drunk driving and substance abuse. And then there was also a panel discussion and conversation from people who had been affected by the results of teen substance use. And that group was compared to another group of teens that was convicted of substance use or DUI and was not required to attend the MAD presentation. And what the study found was that there was no change or no difference between the two groups in their likelihood to repeat substance abuse crimes or driving under the influence. And so as a result of that, the argument was that the court-ordered counseling session for these teen substance users did not have any benefit at all. However, someone argued that it does work. In a different study I found relating to adults and substance abuse, the clients who were mandated to attend treatment in lieu of a prison sentence, or if they didn't go, they would go to jail for their substance crime or substance abuse related crimes, actually had a higher completion rate of treatment and less of a relapse percentage over the group of clients who voluntarily committed themselves to treatment. There might be a couple differences between why some say it doesn't work and some say it does, especially relating to these two studies. Motivation is one of those keys where some of these teens may not have had as harsh of sentences to carry out if they did violate their probation or relapsed in their substance use, whereas the penalties for the adults were more severe, and so they were therefore more motivated. That may also be true for the voluntary clients who brought themselves to rehab, so that they would be more free to leave if they wanted to and had less consequence for relapsing, whereas some of these mandated clients had harsher penalties if they decided to relapse, which may have led to their success in completing the program and less relapse. So overall, what this means, that the outcomes might be treatment specific and also dependent upon that individual who's experiencing the court-ordered counseling. I don't think there's a one-size-fits-all. We'll get into some of the concerns of court-ordered counseling soon, but there is mixed debate on whether or not court-ordered counseling works or doesn't work. I think what we can say is that it would depend on that person and what external or internal motivations affect what has put them in that circumstance in the first place. So what does this mean for counselors? If the jury is out on whether or not there are benefits to court-ordered counseling, what things do counselors need to take into consideration when thinking about whether or not to work with court-ordered clients? This is where a tremendous amount of the research actually fell, was not whether or not it worked, but what some of the ethical concerns are in actually practicing with court-ordered clients. Now, if you remember back to the beginning of my presentation, we talked briefly about the core tenets of informed consent, voluntary participation, confidentiality, and not doing harm. Some of these are blatantly violated if a client is court-ordered for counseling because they're not consenting, they're not there voluntarily, their information is not kept confidential, and depending on what the client or the counselor reports on that client when violating confidentiality may actually harm that client in terms of what that client thinks is in their best interests. And so these core tenets of counselors having responsibility and an ethical obligation to allow clients these certain items is actually all violated. And so there are many of the researchers and articles that were published on the topic are very adamant that you cannot actually build trust and rapport with a client that you are not able to practice those core tenets with. If they can't agree to be there and they are involuntarily committed to you, can they actually trust you? What is that therapeutic alliance and therapeutic relationship? Are there actually goals that can be accomplished if they feel like they're forced to be there? If the client is not ready to change, a lot of times they're labeled as hostile or resistant, but really they're just forced to be there and they're frustrated that a judge is telling them that they have to attend counseling or they'll lose their kids or that they'll go to jail for their DUI. And so they are very unhappy with having to be there, and you can't actually gain that informed consent or protect their information which are some of the most important things in having a client trust you. How can the client trust you if they know that you're going to turn around and they're not going to know what you're telling the judge or their probation officer about what they confide in you in those counseling sessions? So there are some blatant ethical concerns and challenges that counselors have to overcome when working with a court-mandated population. Additionally, liability and fraud were concerns that were raised in the research. Fraud being the idea that the counselor sort of knows that the client doesn't want to be there, and the counselor may accept, the money for treating a client, but because they know they don't want to be there and they don't really want to work on anything, they might not really put their full diligence into working with that client and helping them. And so it's kind of okay, I'll treat the patient because he's here, but I won't really go through all the steps I would for a typical voluntary patient. And so there might be some gaming of the system that some researchers cautioned counselors from doing if they work with court-ordered patients. Lastly, liability is another challenge. So to what extent are counselors held responsible for the actions of their clients outside of sessions? If the client has to be there, refuses to set goals, and generally is, again, not ready to change and is hostile to the process, and then leaves your practice and commits another crime or assaults another person, there's a concern of lawsuit against the counselor for not doing their job or what they are expected to do in, quote unquote, fixing these court-ordered clients. So many challenges to look out for when working with this population. Furthermore, there are multicultural concerns that counselors working with court-ordered clients will need to take into consideration. Regarding prison statistics, the jail population is currently made up of about 58% African Americans and Hispanics. However, they only make up 25% of the United States population. So there's a very disproportionate amount of African Americans and Hispanics who are in jail in comparison to other ethnicities. In terms of drug offenses, African Americans are sentenced at a rate 10 times higher than Caucasians. And so if you are a counselor who is going to see court-ordered clients for substance abuse convictions, that counselor needs to be prepared to work with a minority population because of the disproportionate amount of drug convictions that minority populations are currently experiencing. Additionally, domestic violence counselors need to be prepared for similar multicultural considerations. For instance, other countries have different concepts of corporal punishment and whether or not it's acceptable. So there may be a country from which a family has immigrated from, and corporal punishment or spanking, violence, however you want to phrase it, against a child as a form of discipline is normal and acceptable and has been practiced for generations, and yet in the United States it may be considered domestic violence, and that person might be charged and ordered to therapy for it. And so again, a multicultural concern that a counselor needs to be prepared to experience when working with court-ordered populations, since there are minority and immigrants who will fall into those categories for treatment. So what do you do if you are a counselor who's considering to engage in assisting court-ordered clients? Well, some authors suggest the best practice for court-ordered counseling is to not do court-ordered counseling. The argument is that therapy is not a replacement for the judicial system, and that because of the ethical and multicultural concerns at play, it is better to simply not engage in a system that supports court-ordered therapy. However, it's not going away anytime soon, and so if a counselor is considering working with court-ordered clients, there are some best practices and some strategies that may help it go smoothly and help you be effective in working with those clients. The first of which is to acknowledge that they are required to be there. The worst thing that you could do is pretend like they are like anyone else coming in the door voluntarily and seeking help. If they are there, again, and might fall into the category of hostile or resistant client, it might be because they were threatened and felt coerced into attending counseling. And so by validating that you understand that they may not want to be there and that they're only there because the judge told them to, or they would lose their kids, may at least help them feel comfortable that you understand their situation. They may also feel like there are issues that they are told they have to work on that they don't actually think are issues. Think back to what I mentioned on the other countries that have different acceptable cultural systems of corporal punishment. If that person feels like they've done nothing wrong and that is not a goal that they need to change, they may not want to work with you to improve upon that goal. So a strategy that counselors can use is to find a mutually acceptable middle ground. Help them see that there is something that they could benefit from and work towards that. Whether it's the exact thing they are required to be there for or not, you can take baby steps and work in the right direction. If you can find something of benefit that they want to focus on and perhaps accomplish that goal that can turn into other goals that you set together, but something that you both agree upon, especially that client. Another best practice is to follow the code of ethics regarding multicultural competence. Of course, that includes removing your own biases and values and validating and making an effort to understand the worldview and the experiences of that client. And so, again, if they are one of the disproportionately jailed or convicted minority populations in the United States, and there are complaints against the system or that it's not equitable, you may validate that and appreciate their perspective and work with them within that. But letting them know that they are not wrong and that, regardless of whatever system has brought them to you, there are still some, again, mutually accepted goals that you can work on together and appreciating what they're bringing to the table. Other best practices include encouraging participation. So again, once you validated the fact that they are there against their will and that you understand their circumstance and appreciate their worldview and experiences, you may also help them to see that there is some level of benefit they can get on some of those mutually acceptable goals, and hopefully they will engage and participate in some ways in that session and find something positive to take from it. Furthermore, reporting minimally. So again, this is another concept found in the Code of Ethics where there are times where you may have to report on your clients, but to A, follow the law, and then B, follow the ethics and the Code of Ethics and not divulge more than is necessary to meet those obligations. In that regard as well, it may help build trust and rapport with your client to know that you are working on their behalf to the extent that you can and that you care about their outcomes and their best interests and their well-being. And so there may be positive impacts as a result of your efforts there. However, one author does caution providers from working harder than the client. If the counselor is stressing out and is tirelessly trying to work with a client who refuses to engage and refuses to participate, again, you can lead the horse to water, but you can't make it drink. It is not your responsibility, according to this author, to really put yourself through the ringer to make a benefit in a client who is so resistant and opposed to being there that they are not going to try at all. So perhaps as an effort of self-care or in maintaining your sanity, don't work harder than the client. Now, of course, if the client is making effort and you are helping them and progress is being made, of course, follow your instincts on that. But if you're the only one who's investing in the situation, there might be something wrong with how that interaction is going. And so that author just wants to protect providers who are working with court-ordered clients to not really wreck themselves over someone who is not motivated to change at that point in time. So in summary, I would just reiterate that there are many ethical concerns when working with court-ordered clients. Whether or not trust and rapport can be built or positive outcomes can be obtained through these clients who many considered are coerced to be there. However, the reality of our system is that there are clients who are court ordered to counseling, and there need to be counselors to work with them, and that in some circumstances, there are positive outcomes that can happen. But there are, of course, best practices when working with them, including validating those situations and helping them find goals that they feel are important and attainable. And if that is accomplished, there may be some benefit to working with those clients. I'm happy to answer any questions you have. Thank you for watching this. My email is listed on this slide, and the following 2 slides are my references for my research paper. Again, if you have questions, feel free to reach out. Thanks.